because the corporate income tax level is lower than the individual income tax level. But the problem that you have there is that if you want to get the money out to the shareholders, there's a second level of tax that may bring the total cumulative tax above a single level of tax. The other big advantage of C corporation is it allows you to carry losses forward into subsequent years. So if a lot of times we'll use a C corporation if we're going into a business where we're anticipating losing money in the first couple of years, because that will allow us to accumulate the losses in the first couple of years. Then when we turn a profit, we're able to offset those losses against the profit. And at some point in the future, after you've used up all those losses, you may end up switching to a S corporation, so you reduce the amount of tax to a single level of tax. The cons, again, multiple levels of tax on the income, that there's, for most smaller companies that are C Corps, and again, these are companies that we encounter that were formed a long time ago and may have inventory or receivables where converting to another entity would be very, very costly. You end up playing this game at the end of the year to reduce the taxable income down to zero, so you're not paying two levels of tax. So you end up sending out a lot in salary or in consulting fees to other companies, and so the tax planning becomes much more important towards the end of the year. You have accumulated earnings tax in certain circumstances. If you have earnings that build up, you end up with shareholder loans if you want to get money out and you don't want to get taxed on it immediately. And when you have a sale of the company, if it ends up being an asset sale of the company, you end up with a double layer of tax, because the corporation is going to pay a tax, and then when the money is distributed out to the shareholders, they're going to pay a tax. Again, today with a business starting, unless you anticipate it losing money in the first couple of years, you're generally not going to use a C corporation in most cases. All right. S corporations. Today, that is probably the most common form of business entity used because there's a single level of tax. The income is earned and the shareholder pays the tax on the income and earns one level of tax. All of the income flows out to the shareholders as it is earned. The advantages are that you can separate out the employment income from the earnings of the company and save on payroll taxes. So right now, the payroll tax limit is about $101,000, right in that area. So on the first $101,000 that a person takes as salary, you're going to pay Social Security tax as well as Medicare tax, about 15 point something in taxes. When you reach the $101,000, the balance you take out as salary continues to incur the Medicare tax of about 3 point something in tax. When you have an S corporation, you can take salary up to the level of the Social Security tax and then take the rest out as distributions and avoid the Medicare tax. So you have the ability to avoid that additional 3% tax. As I said before, there's a single level of tax. There's no corporate level tax. Everything flows out to the shareholders. And there is one level of tax if the business is sold. There is a certain election that you can make. If you dissolve the company in the same year that you sell it, you only pay that single level of tax. Any questions so far on C corporations or S corporations? Excellent. I must be doing a great job. All right. Partnerships and LLCs. These are the trendy entities. These are the new entities that are coming out, even though they're not so new. There are statutes in each state that govern how these entities are handled, and there's a whole host of different types of entities. There's single-member LLCs, multi-member LLCs, and now there's something called the series LLC, where you can have one LLC with different series owned underneath, where each investment and each series is deemed to be a different entity by the IRS for tax purposes, and you can vary ownership and vary control. So there's a whole host of different types of LLCs. There are only a few states that have those series LLCs. On the partnership side, there are general partnerships, there are limited partnerships, there are limited liability partnerships, there are limited liability limited partnerships, and so there's a whole host of different ways of doing it. And in Florida, though we don't have the series LLC, we have all of these other entities to choose from. And what's very interesting, the IRS a few years ago passed something called the check the box regulations. And what that allows you to do is form a legal entity and elect to have it taxed as a completely different type of legal entity. The most common way that we see this being used is someone is going into an active business, and they form an LLC as the active business legal entity. The problem with owning an LLC as an active business legal entity is the IRS treats all of the income earned in an LLC as self-employment income. So you're going to pay Social Security and Medicare on the first $101,000, and then the balance of the income above that, you're going to pay the Medicare tax of 3-point-something%. But you can elect to treat the LLC as an S corporation for income tax purposes. So what you end up having is you have the advantages of the LLC as a legal entity for state law purposes and treat it as an S corporation for tax purposes. And in an active business, that's our preferred method of having businesses formed with that kind of a structure. All right, what are the advantages? When you have a partnership or an LLC, taxed as a partnership or an LLC, there's a single level of tax. It's all taxed to the owners, to the members or the partners, and a single level. There's also liability protection. In both limited partnerships and LLCs, the owners are protected from the liabilities of the individual, of the business contained in the entity, and the entity itself is protected from the liability of the owner. In the case of a limited partnership, in Florida and in a few other states, we even have a statute that says, I own an interest in a limited partnership. I get into all kinds of financial trouble. My creditors can't even take ownership of my interest in the limited partnership. The only thing that they're permitted to do is put a charging lien on there, which says, if I get any money out of the partnership, they're entitled to it, but they can't touch my ownership